like the 5 that we're challenging here, out of time, as our papers make clear, and they put us, and I love this term, in a Hobson's choice. We could either go out and hire 10 people at a cost of $1 million to participate in these audits that are exactly like the ones we're challenging before this court, and have 2 really bad things happen to us. Moot our appeal, wasting your all time for reviewing the briefs and getting us to this point, and putting us in a situation where we are put into default and could have our contract terminated after 11 years of faithful service, where their contract administrator says we have met our key performance ratings 99.9% of the time. There's no dispute here that Image API has done everything it contracted to do. It's had its contract renewed twice. Let me spend just a couple of minutes on this thing called a retrospective cost settlement contract. We think the statute is unambiguous, and you certainly don't need to go to aids to construction, that you go to the Supreme Court cases that say must means must. There's probably 6 of them counted in our brief. And on sovereign immunity, it's all Texas Supreme Court cases from 2000 to 2010 that, as I was described, a lawsuit against the state official. So on those 2 points, I threatened that it was going to be all Supreme Court and all Amarillo Court. I'm making good on that. The 3 or 4 cases we cite on must means must, or Supreme Court, and that the plea of jurisdiction was appropriately overruled, all Texas Supreme Court, all this century. What's sort of insidious and unfair about this, Judge, is, and why these things have to be timely. Our brief is really strong on all the reasons why fairness requires this. But they came in and audited after 5 years, after a completed contract, and they said you overcharged for labor in year 1. And as it turned out, same thing, year 2, year 3, year 4, year 5. So they deprived us of the opportunity to either convince them they were wrong or change our ways.
Let me ask you a question related to that. I understand your argument on focusing on the phrase must be completed. I want to focus on the 6 words before that. And those are the words, an audit required by this section. Could the state have performed other audits if it had chosen to do so under other statutory provisions, or even on its own basis?
Yes, it could. It had a lot of contractual rights to audit, and our transparency during that period was overwhelming.
There's not a 1-year limitation on the state's power to do so there, is there?
No. They could have done other ones, but it is undisputed that the ones they did were under this statute. And they even admitted in some internal documents that they weren't timely, under the statute. So, yeah, Judge, I just want to make it very clear that
timely under what part of the statute? The provision
must be done within the year after the audited year.
Because there's that other provision that says you should do your audits in a timely manner or something like that.
Well, I think in any statutory construction, the specific is going to control over the general. And if you say any reasonable time you're reading out of the existence, the very specific must be completed within the year after.
Does the existence of both phrases or both sections, does that create an ambiguity?
I don't think so, Judge. I think that they're harmonizable, that they're supposed to be prompt. And then the definition of prompt is made a little bit more specific in the next 12 words.
What's the significance of the contractual provision that you maintain your records for 7 years?
Your Honor, if you look at that, as we did in our brief, that is a classic record retention provision. You can't throw them away before 7 years. It doesn't have anything to... It's I hate to use the term boilerplate, but it's in almost every contract when a contracting party how long they have to keep the relevant documents, and that's all that is. It's worded just like a document retention provision, and it is a document retention provision.
Do we know anything from the legislative history about this must be completed section? I think there are two ways it can be reviewed. If it must be completed, that the legislature intended for that to be a vested right that contractors have, or that this was a provision the legislature put in place just to make sure that audits were timely performed.
I think it's the former, Judge, because of these kind of contracts, according to even their internal documents from their internal auditor, are so needy of a prompt audit. I think it's the vested right, as opposed to just sort of precatory language on when would be a good time.
The lack of consequence.
Say that again, Judge?
The lack of consequence if you don't do it within a year.
You mean like a penalty on them or something like that? We talk about that in quite a bit of detail in our brief, Judge, but I just don't think that can take away from the mandatory aspect of it in a case like this.
Recently in a child termination setting, where the statute requires the trial court to set certain dates when it returns the child to the parent. One of the dates is trial date. Set a trial date. And the statute says you must set a trial date. And we recently said, well, there's no consequence attached to the failure to do that. Thus, dismissal was not warranted because the legislature didn't do that. How is that different than something like this?
I think the cases that say when it goes to the heart of the consideration in the contract for a contractor, that trumps. It is so important that, and there is a consequence, and that is that they have to prove up this debt against us de novo. Let me be real clear on that. If they want to have a trial about whether we owe them money back, we're not leaving them without a remedy. If they want to sue us in court or in SOA and for a refund, if you will, we'll defend that. But they just can't use these untimely audits as a presumption that we owe them money. So the consequence is if they don't do them timely, Judge, they don't get to use them.
Thank you, Counsel.
Good morning. May it please the Court. Sovereign immunity bars Image API's ultra-virus claim because THHSC acted within its discretion in auditing Image API, and Image API asks the Court to read a limitation into the statute that isn't there. Therefore, this Court should reverse the trial court and instead render judgment that THHSC retained its sovereign immunity from Image API's suit.
The limitation being you must do it within a year.
The limitation being that if you don't do it within a year, you are thereby barred from doing it at all under this statute. So looking first to the statute is directory and does not contain this bar to audits after a year that Image... It says must. So, in determining whether must is a condition precedent or if must can be read as directory, there's no single test. The court needs to look at the totality of the circumstances in determining whether the must means mandatory, which is the default, or if the circumstances in the statute indicate that must should be read in this statute as directory. Here, looking first to the text of the statute itself, you should find that the statute's must is actually directory here. I would direct the court to the purpose of the statute, which we've touched on a little bit already. Here, the purpose of the statute is to ensure, just from the text of the statute itself, is to ensure that the state is conducting audits of its Medicaid contractors, as defined in the statute, based on the risk to the state. So here, what the essence of the statute is to conduct the audit. The essence is not the timing provision. And where the purpose is the audit, you should read the timing provision as directory to allow HHSC to conduct these important audits of its Medicaid contractors based on the risk to the state to ensure that the state's funds are being utilized appropriately. Additionally, as the court has already pointed out,
Right. When's the cutoff?
in the statute, there isn't one.
Oh,
So
okay.
here,
So you can go back 20 years and do an audit? You can go back 30 years and do an audit?
under the terms of the statute, under the terms of the statute itself, there isn't a hard cutoff. The
So
practical
you can go
cutoff,
back 20 years, 30 years and do an audit?
under the terms of the statute, yes. As a practical matter, as the court has already pointed out, there's a records retention policy that serves as the natural limitation for HHSC's ability to audit this contractor.
What's the consequence then of the language saying it has to be completed before the end of the fiscal year? If it can be done at any point, then who cares what that language says?
I think the language is, the purpose of the statute is to conduct these audits. And HHSC agrees that timely audits are important, so we should be and attempt to, when at all possible, conduct these audits within the year when this statute applies. We disagree that it applies to Image API at all, but assuming arguendo that it applies, we do recognize and attempt to do them within the year. But the reason the court should give this a directory construction is that looking first at the text, but then beyond the text to the consequences of this mandatory idea of the mandatory 1-year bar, there's no protection in the statute for HHSC if, for reasons beyond its control, we get beyond that 1 year. So what actually happened in this case is HHSC had planned to audit Image API and had a auditor set up to do that. And then the auditor fell behind schedule, and HHSC was required to go out and go through this lengthy state procurement process to procure external auditors to do the audits instead. So the statute, if we give it a mandatory must means a bar after 1 year reading, would leave HHSC with no recourse to conduct these important audits when something like this happens where the auditor gets behind.
That's not true. You've got inherent within your agreement, you have the ability to audit after the fact, and it doesn't seem like there's any timeline for an audit that way. And I think opposing counsel pointed out just a minute ago, if what we're really trying to do is recoup the fees that are allegedly overpaid in wages, certainly litigation could be something you could do as well. So I'm curious, getting back to the language I focused on a while ago, it seems to me that maybe you missed this deadline under this timeline, but that you have other ways to get what you're trying to get, just not under this provision.
Well, let me back up a little bit, Justice Doss, because I think there's a bit of a confusion there inherent in your question. So HHSC...
There's frequently confusion in my question.
Then this is we've got a lot of briefing in this case. So HHSC doesn't agree from the outset that this statute applied to these audits.
Yeah.
Okay. So
We'll take that for...
when HHSC conducted these audits, it was conducting them under the terms of its contract. And under the terms of the contract, the only limiting factor in the audits is the records retention period. So in reality, those are the audits we were conducting, audits under the contract. It was only after the fact that Image API came in and sued us and said, no, this statute applies to us, we are a Medicaid contractor, and you were therefore limited to the 1 year time period. So for Image API to say today, oh, well, HHSC can conduct audits of us under something other than this statute is disingenuous, because that's what we did. And then they sued and said, oh no, you can only audit us under this statute, and you were untimely under the statute, so the audits were barred. So
What do you base your argument that you're auditing under the contract versus the statute?
we are auditing under the contract because the statute doesn't apply to Image API.
Oh, because they're not Medicaid.
Correct.
If the statute were to apply, if we were to construe that arguendo, then you would be ipso facto auditing under the statute?
Correct.
Why wouldn't you have both gates to go through. I mean,
Well,
you could audit under both the contract or under the statute that it
I
chooses to do.
I don't want to argue for Mr. Ravel, but I think that Image API's position in that case would be that we cannot contract around a statute. So if the statute controls, then the statute controls. And we can't have a contrary provision then in our contract. And in fact, the parties knew, of course, about this statute when it entered. As Mr. Ravel pointed out, they're about to enter their third contract now. They've been contracting together since 2009. They knew about this provision when they entered the contract. It's referenced in HHSC's kind of general contract terms, and it is specifically not applied to Image API through the contract. So the parties themselves didn't believe that this provision applied to Image API.
Now back up, would you say that again?
Sorry. So, Justice Pirtle, the parties going back to 2009 have contracts together. HHSC's general contract terms include an optional provision that would apply this statute to the contract. The parties in neither of the contracts that are in evidence, they specifically did not apply that optional provision. So the parties' contemporaneous understanding when they entered the contract was that the statute here, this audit statute, did not apply to Image API's contract. Image API only came in after we completed audits and discovered that they had been overpaid by $1.8 million. They only came in then and said, oh wait, this statute applies to us, so the audits were untimely and are therefore barred.
Let me simplify that by my simple mind. I can envision a contract. I apologize, I haven't read the contract. And I can envision a contract that says section, whatever one is applicable at the particular time, applies to the terms of this contract. Parties agree to it, and by contract, you're agreeing that they are a Medicaid contract. Fine. Or they could just as easily say section doesn't apply to this contract, and you're agreeing that they're not a contractor. And you're saying that that is a provision in a printed contract, and they chose not to use it?
So HHSC has what they call uniform contract terms and conditions because it's such a large, state contractor, and it has this section that is kind of a checkbox section with optional terms that it's in their, boilerplate language. So you can go through and check the optional terms. So what we're relying on here is that one of those is a checkbox that says, yes, 32.0705 applies, and that has been left blank in these contracts.
Is there a comparable checkbox that says that statute does not apply?
Because if you check the box, then the statute does apply.
No, is there a comparable?
Oh, no, sir. No, sir. There's not a separate, I think your question is there a separate one that says this does not apply, and was that checked? No. There's just this does apply, and it was not checked, if that makes sense.
Yeah, so are we to assume from that it does not?
That was the party's contemporaneous understanding, yes. Of course, as I was just saying to Justice Doss, HHSC can't contract around a statute. So if it applies, and we can't render it inapplicable through a contract. But the court can look at, even when we're looking at an unambiguous statute like this one, the court can look at the agency's administrative construction of the statute, the contract being one of the things that are in the record the court can look at, as evidence of whether the agency thought this applied. And I think that's useful here because this is a statute governing the Medicaid program, and HHSC is the entity that the legislature has charged with carrying out Medicaid. So at some point, the agency gets a little bit of ability to determine, okay, we're the ones who run Medicaid. Here's the definition of Medicaid contractor in the statute, and how are we going to apply that to our contracts? And here they've drawn the line of Image API is not a Medicaid contractor as defined in this particular statute. So going back to the statute, you had asked Justice Doss about the legislative history and whether that offers us any indication here about...
Under 320705D, whether there was any legislative history dealing with what we mean by the phrase must be completed. if the legislature has said anything one way or another on that.
No, as I recall, there was not any useful legislative history, and here this was a fun situation where the legislature passed 3 statutes in the same session without reference to the other. So digging through the legislative history, there's nothing, we didn't include anything in the record, and as I recall, there was nothing useful in the legislative history to help us decide how we square B3, which is the complete, timely, if possible, and D, which says 1 year. Turning to, the court should reverse just on the basis that the timing provisions are directory, and therefore HHSC retained its discretion to audit Image API. But as a separate and independent basis on which the court should reverse and find that we retained our sovereign immunity, also, the statute just doesn't apply to Image API. They are not a Medicaid contractor, as that term is specially defined in the statute. First, the statute applies only to certain Medicaid contractors. It's not anyone whose contract touches on Medicaid. It's only certain Medicaid contractors as defined in the statute. And the statute, yes, sir.
Go on. I think you're about to answer the question I was going to ask. I think. Go on.
That's a lot of pressure. I don't know that I was. So the statute, to remind the court, says that a Medicaid contractor performs one or more administrative services in relation to the Commission's operation of Medicaid. And then the legislature has provided us with a non-exclusive list of what those services are. Yeah, examples, correct. Yes, sir.
What does in relation to mean?
In relation to the Commission's operation of Medicaid is probably the most difficult phrase in the statute because it's fairly broad, and we don't have any indication of what the legislature meant by in relation to here,
There was, and I guess it's still in there, may not be, the TCPA, you know what that is? Texas
a little bit, yes, sir.
Texas Citizens
Mhm.
Participation Act, when they were talking about whether or not certain enumerated conduct speech was in relation to
Mhm. Yes.
First Amendment. Do we look at how the Supreme Court interpreted in relation to there and apply it here?
I'm not familiar with how the Supreme Court interpreted in relation to, in the context of the TCPA.
That's a good answer.
Yeah, it's hard to answer that question. I don't know that, because we should only look at the way.
They looked at it and they interpreted it very broadly, like you said, very broadly.
I think it
like
is
even touching upon broadly.
I think it is fairly broad here, but the legislature has helped us by giving us a list of the types of things that are in relation to the operation of Medicaid.
For example, if the statute said that they perform administrative services such as client enrollment, then that would indicate to me that client enrollment was the task that was actually to be performed. But if we're talking about a task in relation to client enrollment, that seems to suggest something different, which would encompass any other activities used for purposes of supporting client enrollment. Does it not? I mean, that's what it indicates to me, but I want you to have an opportunity to talk about that.
So my understanding of the statute is that we're talking about that we should read the first phrase together, administrative services in the operation of Medicaid. That's the definition. And then the legislature has said, and what we mean by that is client enrollment, provider enrollment, et cetera.
But in relation to, you look that out.
Oh,
It actually says
I do-
administrative services in relation to.
Administrative services in relation to the operation of Medicaid. And then the list is supposed to tell us what the legislature meant by administrative services in relation to the Commission's operation of Medicaid. So to give you a
Receiving the
concrete...
mailing, receiving the application in the mail, isn't that a prerequisite to enrollment, so to speak? I'm not sure how the system goes, but, and if you never get that, you can never have an enrollment. So receiving it, processing it, and giving it to can be considered in relation to.
So yes, Chief Justice Quinn, it is very far down the line, right? So I think this goes back to...
But it's pivotal, isn't it?
Image API receives paper applications and scans them into an electronic form. Then there is, and only...
But if
Oh,
nobody
excuse me.
did that, you would have no purpose with regard to Medicaid. You wouldn't be able to function, do whatever you do with Medicaid.
Nobody would.
It's for the paper applications, yes, which is a vast minority of the applications HHSC receives. But it is important because it allows vulnerable Texans to apply who don't have access to other means of application. But the statute, looking at the terms of the statute, is about auditing certain Medicaid contractors, which is in the title of the statute, based on the risk to the state. So again, we're not looking at, by the terms of the statute, at any contract, but at these specific contracts in relation to the Commission's operation of Medicaid. What Image API does is a scanning service for HHSC for a number of different programs, some Medicaid and some not. Those documents then go to a different contractor who performs optical character recognition so that they can be, easily used. Then it goes to another contractor who actually tags those documents to the appropriate files. Then it goes to HHSC to make the eligibility determination. Then it goes to enrollment, and say it's a Medicaid program, it hops over to the enrollment side, and it's determined whether an individual can be enrolled in Medicaid. And then there's a whole other group of contractors to whom this statute clearly applies, called managed care organizations. In Texas, we have Medicaid managed care. So once a client is actually enrolled in Medicaid, then they are assigned to a specific managed care organization. And those are the Medicaid contractors under this statute who are doing the provider enrollment, client enrollment, paying the claims. So HHSC's position is that's who this statute was intended to capture.
You argued in your brief that you didn't believe that what the other side performed was an administrative service, and I know you're running short on time, so I wanted to give you an opportunity to address that. But let me ask you this, because I was doing my own definitional research, and I came across a definition on vocabulary.com. So we'll need to see if this is a legitimate definition or not. But here's what it says. If your job is administrative, you're pretty much limited to paperwork, check writing, or maybe hiring and firing. Administrative means having to do with overseeing the officey things. And the officey things, that language is actually in here. How is this not an officey thing? It's processing paper and putting it into the system so that it can be used for client enrollment and things in the future.
It is if we just look at the term administrative service, it's certainly an administrative service the way we understand that term. May I finish my answer? Okay, thank you. The way we generally understand administrative services, like you said, scanning, we think of that as an administrative service. But there's a second way to think about administrative services that makes more sense when you read this as administrative services in relation to the Commission's operation of Medicaid, which is administering an organization, right? The management of an organization. So when you read the term as a whole, that leads us to the definition that's more of a management thing than a clerical matter. So for these reasons, we ask that you reverse and render judgment that the claims are barred by sovereign immunity. Thank you. Thank you, Justice.
The court seemed very interested in whether they audited under the contract or audited under the statute. And the record is indisputable that they audited under the statute, only under the statute. The executive commissioner got a memo that said, you need to go out and audit Medicaid contractors under this statute. And then the procurement listed Image API by name as a Medicaid contractor, which is an incredible pre-suit admission by the department that they know we're a Medicaid contractor. And I think the court has got a handle on, because we do the officey things, and because we are the domino, that but for us, nobody could get enrolled, that we're a Medicaid contractor. So common sense, their admission pre-suit, and all of the matters of contract construction that lead you to a conclusion that this massive scanning process is an administrative service, plus their admission that it is.
I guess your argument would be, correct me if I'm wrong, given the relation to, it does not matter how incidental the services are to the process if they're any part of the process you fall within.
Well, I don't want to concede that they're incidental, Judge.
I understand,
But
you do processing for a lot of different things for the
Yes.
agency. Let's assume, arguendo, only 5% is related to Medicaid. Your argument would have to be that that's enough.
well, I think the
It's
argument.
still related to Medicaid.
The argument is not only, assuming 5%, which it's a lot more, but we do all the Medicaid. Nobody else does Medicaid. So that's the best evidence that we're a Medicaid contractor, is we are the only Medicaid contractor. And the discussion of the progression to the procurement that hired the auditor that audited us, is discussed in a lot of detail between like page 34 and 40 of our appellant's brief. But it is overwhelming, judges, that what was going on in the top echelon of HHSC is we've got to do an annual audit under this statute of our Medicaid contractors, and the procurement listed us by name. I don't know how you get around our being a Medicaid contractor when you have that, plus everything else that we've talked about here today. Sovereign immunity, again, our brief covers it really well. It's Hornbook law that if you're suing for the breach of a ultra vires, the violation of a statute, that there's no sovereign immunity for that. And auditing outside of a statutory prohibition is the epitome of a Cobb versus Harrington claim. So let me sum up that this court's...
Actually, just out of curiosity, they find 2 years, 3 years down the road after the end of the fiscal year, they find what they deem to be some problem, in that they believe they're entitled to some money. They sue you to recoup it. Can they garner the documents they need in order to do the audit and discovery?
Sure. Well,
They'd be conducting an audit.
well, they would be conducting discovery in a breach of contract for money damages case. Well, what our beef is that these audits shouldn't be preclusive. They shouldn't be summary judgment for them in this later lawsuit. And let me end with how transparent we are. We tell them what we've spent and what we've spent it on monthly, quarterly, annually. I just can't imagine coming in and saying 5 years later, we've got to be able to do these anytime because they're so important. In 2016, they asked to audit back to 2010. In the summer of 2021, they asked to audit back to 2015. Just not fair, Judge, for the judges, for the reasons that I mentioned. Deprives us of the ability to fix the problem or to change their minds. You know, just a little equity to go with the straight law. Any questions for me?
Counsel, you're out of time, and I hate to open Pandora's box, but what are we to do with this motion before the court about the judgment?
I think you follow your earlier case to the letter. You look at, you compare the one I had to stumble over the spelling.
Well, what is the significance of trying to suspend the enforcement of a judgment that does nothing more than deny your motion for summary judgment and grant the department's motion?
Hobson's choice, Judge. Either we spend $1 million participating in these audits that they've noticed, or we let this appeal, which we're pretty invested in, be mooted, or we risk being put into default and having a contract that we have performed fully for 11 years. So that's the reason, is the status quo until the summer, 6 weeks ago, when they said we want to audit at a time 5 more years, was we were going to get guidance from the courts, and then we were both going to live with it. They can't cut that process short. They can't say to the Amarillo Court of Appeals, all of a sudden the filing fee for Image API is $1 million and 10 employees, or they lose their appellate rights.
Well, there's no injunction in place. If they want to audit for this new contract within the last year, what's to stop them from doing that?
If they did that, we would come to this court and ask for an injunction to preserve your jurisdiction.
Why would,
That wouldn't even be within our jurisdiction. That's not an issue before this court.
Well, the issue of whether the audits are proper or not are, in time or not.
But fiscal year, if they sought to audit within a term defined by the statute, and apparently that's what they indicated they were trying to do, I thought.
I think they admit they're outside of the time. But we'll stipulate that if they do it timely, we'll participate in it.
That's all I was concerned about. And I didn't understand what we were accomplishing by suspending him.
If they'll notice it within the statutory interval, we're all in, Judge. That's our responsibility under the statute. We're not going to shirk it. We also are not wild about expanding it.
one more question related along these lines, because there's also a 7-year document retention policy. Are you going to retain the documents beyond the 7 years during the pendency of the appeal, if that's what it calls for?
I'm not 100% sure we are, but I think I can represent. I know that we will now that you raise it, but I don't think we've gotten rid of anything back to 2010.
Possibility, I guess, based on the litigation claim too, if you got rid of them.
We'll play fair, Judge, under the contract.
Thank you, counsel. The case is submitted.
My apologies, I thought I got a rebuttal response.
Well, we didn't talk about that. We talked about 2020 and 5, and nobody asked for additional time.
Oh, I'm sorry.
But given that situation, we were all packing up to leave. I would ask next time. No, it's okay. Let me stop the clock.
I do apologize. I thought you said 5 and 5, and I had
No.
spoken to your clerk earlier, and she had said 5 and 5, so.
No, nobody had asked for that.
Okay, my apologies.
But next time, go on and ask to make it clear. But we will give you this, 5 minutes.
Thank you, Chief Justice. I appreciate the time. I wanted to spend a moment speaking about the motion that was before the court, since the justices had questions about that. Our motion for this court to review the order suspending enforcement of the judgment is primarily raises legal claims. The first being, as Justice Pirtle was talking about earlier, that when you have a take-nothing judgment like we had here, Rule 24 about suspending enforcement of judgments just doesn't apply. When the judgment doesn't do anything to change the relationship between the parties, there is nothing to supersede and nothing to be counter-superseded, et cetera. So Rule 24 just doesn't apply, so the court shouldn't have taken any action on the motion in the first instance. But even if it...
Question.
Yes, sir.
If the summary judgment stands, would that allow you to conduct an offset against what you currently owe API for current services and offsetting what you deem they owe you?
I think that's correct, that if the summary judgment
So
stands...
There is a potential monetary consequence if the summary judgment stands.
If it stands at the end of all appeals in this case, yes.
No, I mean if it remains enforceable right now.
We could do that. I think that's correct, Chief Justice. I have said to Mr. Ravel that we will hold off on any recoupment until the end of all appeals in this case. We're a state contractor. We are a state agency. We have an ongoing contract with Image API. We're not in any way trying to destroy them. we're willing to wait on the recoupment or repayment until all appeals in the case are done. Our issue is we want to be conducting these audits so that we don't just have compounding errors like they faced before when we got behind. So we want to know if there's something going on so that we can engage in error correction if needed. So what's important to HHSC is to conduct the audits. We have represented in our papers before the trial court and this court that we will not attempt to recoup and if there is something to be recouped until the appeals in this case are done.
Isn't there an equity factor against you, though, given the delay that it took to begin the audits up until now? That on the one hand, there's a delay in getting the audit started, but now that we're in litigation, by golly, we want to get these audits going.
Well, we waited. We voluntarily held off on any further audits while the case was in the trial court. But once we received a favorable determination from the trial court, we went ahead almost immediately and started procuring additional audits. Yes, sir.
Okay,
No.
I think you have a question.
Oh, I'm sorry. I thought you had a question. So we waited until we received a favorable determination, and then we did a public procurement process that resulted in us putting out notices to Image API that we would be auditing a block of time, 2015 to 2020. When we issued those notices, 2020 was timely under Image API's theory of this case, but Image API refused to participate in any of the audits, and it became untimely while we were waiting for the trial court to
Why
rule.
don't we maintain everything status quo prior to judgment by denying the motion?
The status quo prior to the judgment was that we had the authority to audit under the statute. So that's the status quo we're trying to maintain.
Why audit anything for which you could not enforce recoupment?
The audits are important whether we can recoup or not. From our ongoing contractual relationship perspective, we want to make sure that the funds are being used appropriately and that if there are any issues with the way state funds are being used, that those are corrected, even if we can't recoup. Because now we have a contract with Image API that's going to go to 2025. So
you're going to expend taxpayer funds to conduct an audit that may show that Image API owes you money that you cannot collect?
yes, sir. We also have obligations. So Medicaid, of course, is
That's to make sure that if there are any mistakes that the agency is performing, you can correct it.
that's right. So it goes both ways. An audit. Oh,
It sounds
sorry.
like you're adopting their argument. They wanted to have the opportunity to correct any mistakes by you conducting a timely audit. So, if we agree with you, how can we not agree with them?
We also want to conduct timely audits, and that's, oh, I'm sorry, I see my time is up. May I finish? Okay. So we are trying to conduct timely audits. We're trying to get back on the schedule, and that's why we went ahead and procured auditors to begin auditing the next time frame, even though the case is on appeal. So the more we wait, the further behind we're getting. If there are errors on either side, they're just being compounded. So that's why we want to move forward with the audits, even if we can't collect. Thank you for your time. I appreciate it.
Yeah.
There's one sentence in survey model. The judgment was December. The audit requests were August 2021, after the briefing was complete finished work. So it was on August 6, 2021, that they asked to audit the calendar year 2015. The record was complete here, and I think one can draw the inference that starving us out of this appeal might have been a goal.
Thank you, Ken. The case is submitted, and you are excused to go, and we'll be in recess to our next settings. And again, thank you for coming up to Amarillo.
And we customarily have our opinions out within 3 years, so.
Just like Austin.